Hey everyone, and welcome to The Explainer. I am absolutely thrilled to have you here today. Whether you're a dedicated law student or just a focused learner who's kind of fascinated by the nuts and bolts of the justice system, you are in the perfect place. Today, we're going to be dissecting a really incredible true crime case by its exact legal name. Manish Dixit v. State of Rajasthan, 2001, 1 SCC 596. This case is a phenomenal study in criminal jurisprudence. Why? Because it perfectly demonstrates that high-stakes tightrope walk between relying on purely circumstantial evidence to lock in a murder conviction and the absolute non-negotiable need for deep judicial restraint. It's a gripping story, and the law we're going to extract from it today is absolutely foundational. So let's dive right into this. To make sure everything is crystal clear, we're going to use a modified IRAC method to break this down. As you can see on our roadmap here, we'll start with 1, the facts of the case, then 2, core legal issues, 3, rules and statutory framework, 4, arguments of the parties, 5, police searches and judicial restraint, and finally, 6, the Supreme Court's judgment.
All right, let's jump right in. Section 1, the facts of the case, the murder of Gulshan Makhija.
So picture this. The victim, Gulshan Makhija, was a really prominent jeweler based out of Jaipur. He's traveling in a car with a friend of his, a German national named Michael Hens. Out of nowhere, the accused intercept them. They literally drag Hens out of the car, leave him stranded on the road, and take off with Makhija. Tragically, the jeweler's body is later found dumped by a roadside with fatal gunshot wounds. Now look at the timeline we've laid out here. Our primary suspect, Manish Dixit, immediately vanishes. Like he goes completely underground at the exact same moment his co-accused gets arrested. Suspicious, right? While he's on the run, Dixit checks into a hotel, and he actually manually writes down a totally fake name in the guest register. Eventually, the police catch him off guard. They find a revolver on him, and the absolute kicker here. A ballistic exam confirms that the bullets pulled from the victim perfectly match the unique rifling marks of Dixit's revolver. Oh, and stolen jewelry was also recovered and identified in a test identification parade.
Now, during the trial, things get a little messy. The judicial officer who actually conducted that identification parade for the stolen jewelry was brought to the stand as Prosecution Witness 30, or PW30. During cross-examination, his answers got kind of ambiguous about whether he meticulously recorded every single minute detail in the seizure memo. And guess what? The public prosecutor completely dropped the ball and failed to re-examine him to clear up that confusion. Because of this gap, yes, the trial court did secure a conviction against Dixit, but the lower courts went way further. They issued these incredibly severe, highly defamatory public strictures against PW30 for what they saw as negligence. This whole thing basically sparked a massive secondary legal war over reputation and judicial conduct that eventually went all the way up to the Supreme Court.
Which brings us to Section 2, core legal issues, evidence and reputation.
Take a look at these 3 pivotal questions on the screen and really ponder how you would rule if you were the judge. First, can you actually sustain a murder conviction based purely on circumstantial evidence when your sole eyewitness, the German national, couldn't even be produced to trial? Second, is a standard hotel guest register legally considered a book of accounts under Section 34 of the Evidence Act? Because if it is, it would require independent corroboration. And third, can trial or appellate courts legally pass disparaging remarks that ruin a witness's reputation without even giving them a proper hearing?
Let's look at the law to find out. Section 3, rules and statutory framework, the legal code. We've broken down the exact statutes on the screen for you to read and take notes on. First up, we have Sections 302 and 364 of the Indian Penal Code. These are your substantive offenses, murder and kidnapping for murder. Next, Section 34 of the Indian Evidence Act. This strict rule outlines the admissibility of entries in books of accounts that are kept in the regular course of business. And third, we have Sections 165 and 166 of the Code of Criminal Procedure, or the CRPC. These basically dictate the mandatory territorial rules and procedural safeguards that cops have to follow when they are conducting searches and seizures outside of their local jurisdiction.
Now, what's really interesting about this slide is that we are moving beyond statutory code and looking at the absolute bedrock of common law, audi alterum partem. It literally translates to listen to the other side. This is a core principle of natural justice. It means that no person should ever be condemned or suffer reputational damage by a court without being given a fair, honest opportunity to defend themselves. Keep this in mind because, as you'll see, this becomes the absolute heart of the Supreme Court's ruling regarding our defamed judicial officer. All right, Section 4, Arguments of the Parties. Evaluating circumstantial evidence.
This was a real heavyweight legal match. As you can see, the defense for the appellants tried to heavily weaponize procedural loopholes. They argued the whole prosecution case was basically crippled without that foreign eyewitness. They claimed the hotel register was totally inadmissible under Section 34 because it didn't have financial corroboration. And they fiercely argued that the weapon recovery violated the CRPC because local civilian witnesses didn't sign the seizure memo, basically implying the cops planted the gun. On the flip side, the respondent, the state, relied on cold, hard physical realities. They argued that the circumstantial chain was unshakable. Dixit's sudden flight, his active concealment using a fake identity at the hotel, and that unassailable, unquestionable ballistic match between his revolver and the murder bullets, they argued that left absolutely zero room for innocence.
Let's see who won out. Section 5. Police searches and judicial restraint. The Supreme Court's reasoning.
So how did the court actually interpret the law here? Well, remember, the defense argued the hotel register was inadmissible under Section 34 without independent proof. But the Supreme Court brilliantly ruled that a book of accounts is explicitly a financial record. We're talking debts, credits, payments. A hotel register? That's just an administrative record to track who is sleeping in what room. Because it's strictly administrative, Section 34 doesn't apply at all. So independent financial corroboration wasn't needed. The register was fully admissible as rock-solid circumstantial evidence of Dixit's deception.
Next up, they tackled that messy police search under the CRPC. The defense claimed the search was illegal because it happened out of jurisdiction and didn't have local civilian signatures on the memo. The court got incredibly real here. They noted two huge practical realities. First, the emergency apprehension of an armed, absconding murder suspect absolutely justifies hot pursuit across jurisdictions. Second, let's be honest, everyday city citizens actively avoid signing police memos. Why? Because they are terrified of endless court delays and the massive personal hassle of testifying years later. So the simple lack of civilian signatures does not automatically mean the police fabricated the ballistic match. But what about PW30, our defamed judicial officer? The Supreme Court came down incredibly hard on the lower courts here. They leaned on the precedent set in State of UP v. Mohammed Naeem, pointing out that the right to reputation is a completely unyielding facet of personal liberty. The public prosecutor is the one who failed to use Section 162 of the CRPC to re-examine the witness and clear up those ambiguities. Just look at this quote on the screen. The court literally said, "A witness cannot be professionally lynched by judicial decree for a gap that the state's processing machinery failed to legally clarify." Condemning that officer without a hearing was a complete and flagrant violation of natural justice.
Which leads us straight into Section 6, the Supreme Court's judgment, balancing justice.
So, here is the final verdict laid out for you. The Supreme Court ultimately severed the valid murder conviction from those procedurally flawed judicial strictures. Step 1, they firmly upheld the conviction and the life sentence of Manish Dixit under Section 302 of the IPC. That unbroken chain of circumstantial evidence, the flight, the fake registry, the ballistic match, was more than enough to establish guilt beyond a reasonable doubt, even without that foreign eyewitness. Step 2, they exercised their extraordinary powers to completely expunge all defamatory remarks against PW30. Those remarks are now treated as legally non-existent. Boom, gone. They fully restored the officer's reputation and sent a massive reminder that natural justice applies to literally everyone in the courtroom.